what you're saying. If the vehicle was not running because of the fuel pump, which they gave the original diagnosis, if it's not running after they fixed it, then
I'm trying to figure out how in a mile you figured that out.
because because when I brought it in, it was running.
The case you're about to watch is a ticking time bomb of courtroom drama. Judge Simpson, known for his razor-sharp legal mind and zero tolerance for nonsense, steps into a storm where accusations fly over a car repair gone wrong. At the heart of this case, a dispute over a fuel pump, receipts, and 2 years of unanswered questions. Was the part ever replaced, or did the shop take the money and run? What makes this trial so gripping isn't just the technical talk about mechanics. It's the credibility battle, the proof gaps, and the judge's relentless push for answers. Watch closely as contradictions stack up, tempers flare, and Judge Simpson's patience gets tested. By the end, you'll see why even the smallest car part can explode into a courtroom war. Stick around, because this is one breakdown you don't want to miss.
I drove it in there when I brought it in.
No. What I'm trying to figure out is, let's say it was running. Let's say everything is as you say it is. When you leave their facility, how do you know the vehicle isn't running?
When we left the facility, it was running. I drove it.
You drove it away from there.
I drove it away.
Okay, so then how, folks?
But it was also running when
It was performing the same way when we brought it in there originally. It was performing.
It's just that what the problem was that it was stalling out, and it.
Okay,
it was
so how do I know in that mile that they had not cured the stalling out?
A fuel pump is supposed to work continuously. It's not only.
Ma'am, I understand a whole lot more about cars than you think I do.
Okay.
And I'm gonna tell you, I understand exactly how that fuel pump works.
Well,
So-
I'm trying to answer your question. I thought it was a question. No,
I asked you a question.
okay. Well, can you repeat the question again?
How do I know that that vehicle wasn't stalling?
Judge Simpson is laser-focused here. He's not debating whether the car eventually failed. He's asking, how do we know in that first mile after repair that the issue wasn't fixed? This is a textbook example of burden of proof. The customer has to show evidence that the shop's repair failed right away, not just months or years later. Notice how he zeroes in. How do I know? That's not rhetorical. It's a demand. Courts deal in evidence, not feelings, and Simpson's drilling into that gap. Without immediate proof, the plaintiff's case is shaky. And this is where jurors or judges often make their mental notes. If you can't prove the timeline, you can't prove liability. Let me ask you, if your car died months later, would you be certain it was the mechanic's fault, or would you wonder if time and wear played a role?
Because when we returned the vehicle, for them to look at it again, as the note say, he gave us another diagnosis saying it's the fuel pump. That was because he didn't remember dealing with or fixing that vehicle that prior year or 13 months or whatever it was. This was his diagnosis that, oh, you guys need a fuel pump.
Because you came in there and gave him the same symptoms.
Well, no, we just said the car's not stop.
And
That's it, very vague.
And they did their diagnosis, and their diagnosis was that the fuel pump needed to be replaced.
Okay, but why is that their fault?
Because they were supposed to replace the fuel pump the first time.
This is the second time. So. They were supposed to.
I'll get back to my other question.
Okay.
They go to O'Reilly's. They pick up a fuel pump. They put the fuel pump on. Right?
Yeah.
fuel pump doesn't work or doesn't do what it's supposed to do. How do you attribute that to them?
This moment is pure courtroom drama. The judge throws the hardest punch. How is this the shop's fault? That's the million-dollar question. Think about it. The shop buys a fuel pump, installs it, and 2 years later the customer says, well, it still didn't work. But Judge Simpson isn't buying the timeline. In law, warranties are limited for a reason. You can't expect a 10-year-old vehicle part to be guaranteed for years on end. This is where contract law and consumer rights clash with reality. Was the shop negligent, or is this just the risk of owning an older car? The tension builds because the judge is hinting without ironclad evidence. Sympathy won't win the case. Here's the kicker. Trials like this aren't about who seems more upset, but who has the paper trail. Would you feel confident taking this fight to court with only your word against a receipt?
Because we rendered their services to fix the pump in the first.
But you then don't bring it back until 2 years later. There is no workplace anywhere that is going to give you a warranty on a part, particularly a 1999, that I'm talking putting a part on a 10-year-old vehicle, that I'm going to warranty that part for over 2 years, because that's what you're asking them to do.
Well, asking them to warranty the part. Yeah, this place says that the original fuel pump was in that vehicle, that fuel pump was not replaced. That's what he wrote.
Okay, ma'am, I can hear, and I've heard you say that. That's not my point. My point is, if in June 9th, 2020, you're saying they didn't replace the part. Supposedly, it's then not discovered until 2 years later, well, more than 2 years later, that part hasn't been replaced. That's your position. Their position is we replaced the part. They're going to show, I'm presuming at trial, they're going to show a receipt for that part.
Boom. The word receipt lands, and suddenly the entire case pivots. Why? Because in civil disputes, documentation is king. A single receipt can outweigh hours of testimony. If the shop produces proof of purchase and installation, that's powerful evidence. The plaintiff, on the other hand, is relying on memory, suspicion, and mechanics' opinions years after the fact. Notice Judge Simpson's framing. Between June 2020 and October 2022, there's a black hole of accountability. That's devastating in court. Evidence has to bridge time, and here, it doesn't. This is a reality check. If you're ever in a dispute like this, keep your records, take photos, document problems immediately. Waiting years only weakens your case. Let me throw this to you. If a mechanic hands you a receipt, do you automatically trust the job was done, or do you double check before leaving the shop?
And they're going to say, we put it on the vehicle. This other place is going to say they didn't put it on the vehicle. Here's my problem. Between June 9th of 2020 and October 3rd of 2022, I have no idea what happened with that vehicle. None. And even you guys don't have any idea, at least for 3 months.
For 3 days. We know it didn't start 3 days later.
3 months. July 2nd, 2022 to October 3rd, 2022. You guys have no idea what happened with that vehicle because it's not in your possession. Go ahead.
We have their diagnosis.
You want to know what? Let's have, okay, when do we want to try this? Because this is going to be too, I'm just telling you.
Okay, well, let's take it to trial. Whatever. Let's do what we got to do.
No, don't tell me, okay, let's take it to trial. Do not play with me like that.
Yes, sir.
Good answer. I'm just telling you right now, you got significant proof problems. Because, can you get that wrong? Because you got 2 years. You're saying they didn't put on the part. Who's going to tell me that that's the original one that's put on? This guy's going to say it looks like the original one. Right? He would have given you a part that, quite frankly, I could go to any junkyard. They got a 1990 Jimmy, I can probably get that part. And somehow or another, you're going to say they bought a part, didn't put it on, and now you're trying to hold them accountable 2+ years after the fact.
Judge Simpson's frustration is on full display here. 2+ years is practically a death sentence for most consumer claims. Think about it. Memories fade, vehicles deteriorate, and parts age naturally. The law demands timely action because waiting this long makes the truth nearly impossible to prove. This is where the judge is drawing a line, not because he doesn't care about fairness, but because time kills cases, and he's blunt about it. If the plaintiff had brought this dispute within weeks or even months, they might have had a compelling argument. But 2 years later, the evidence is muddy, and the shop can argue anything in that gap. You can feel the exasperation in his tone. I really don't know how you're going to show that to me.
And what I don't know, and I'm just being blunt with you. What I don't know is that whatever they did, that it didn't work. I mean, folks, just hear me out. It's one thing, you take it in there on June 9, 2020, and let's say you get it to somebody July, let's say 1 month after the fact, right? And you get it to some place and they say, this part hasn't been replaced, here it is. That could be a compelling case if they didn't put it on. But what you're asking now is that and by the way, that it was doing the same thing, right? Right after the repair. Here, you can correct whatever you think is different about the story, is 2 years plus, really 25 months. After they supposedly have the part, I take it back saying it doesn't work. Or that what happened didn't work. I don't even know how you're going to begin to show that to me. I really don't. Yeah.
So if once we bring it back to their shop and he agreed, okay, we'll take care of it, we'll fix it, no problem. With him agreeing to rectify that issue, all that time later, that has no bearing on.
Well, what is he rectifying though?
The faulty part at that point.
Is he really rectifying the faulty part?
That's what he agreed to do.
No.
No?
Because, hold on a second. At the time, you don't know that the part is faulty, do you?
No, I do not.
Here's where the case takes a fascinating twist. The plaintiff argues the mechanic agreed to fix it later, but Judge Simpson dismantles that in seconds. Why? Because intentions don't equal proof. Just because a mechanic agrees to take care of it doesn't mean they're admitting guilt. Sometimes it's customer service. Sometimes it's a gesture to avoid conflict. But in court, the judge wants clarity. Was the part faulty, yes or no? Without knowing that, the mechanic's words are vague promises, not admissions. This is a great reminder that courtroom battles often hinge on precise language. What sounds like a confession outside court can collapse under scrutiny inside it. The judge's sharp questioning exposes the plaintiff's weak foundation. Let me put it to you, when someone promises to fix it, do you assume guilt, or do you take it as goodwill until proven otherwise?
So if you don't know that it's a faulty part, how is he trying to rectify the faulty part?
Maybe because they've already done a diagnosis and they see it's the fuel pump. This was after the diagnosis, the second diagnosis. And he agreed, yeah, we'll take care of it.
Okay. We'll take care of it. So what's that mean? I've got a customer that wants something done. We'll take care of it. Yeah.
I'm curious, if he's the mechanic, how long is the fuel pump supposed to last in the vehicle?
Well, man, that's going to depend. I mean, I know enough about fuel pumps. I mean, you can put one in and it's operating just fine, but there are other parts of the system that are relying upon that fuel pump. And so, I mean, you can get a defective fuel pump.
Mm-hmm.
I mean, that can happen. But I can't even say that's what happened in this case.
But the evidence from the other shop, he states that the components, he can clearly see that the components for that fuel pump were not touched. He said once those straps come off, they're broken. They need to be replaced. These are still.
How do I know that didn't happen?
Because he said so. He's the mechanic.
No, ma'am.
We didn't, because listen, if we didn't drive the vehicle, then everything's still going to be new. Why would it be used if it's not being used?
Ma'am, that's part of the proof problems, isn't it?
Judge Simpson delivers the hammer here. He's pointing to the 2-year gap like it's a gaping hole in the case. Think about the logic. If the car sat unused for years, who knows what happened? Did other mechanics tinker with it? Did natural wear and tear take its toll? Could environmental conditions have played a role? The plaintiff is stuck because proving what didn't happen over 2 years is almost impossible. That's why the judge calls it a proof problem. This isn't bias, it's the cold, hard structure of legal responsibility. Burden of proof always sits with the claimant. Without airtight evidence, the argument collapses. And you can feel Judge Simpson losing patience as he explains the obvious. The clock matters as much as the facts.
I mean, that's what I'm saying. Part of the proof problems is this vehicle sat for 2 years.
So the parts are still new.
They may be or may not be. I mean, you're going to have to account for every day that vehicle's sitting.
But
I mean, you can laugh about it or not, but the burden's on you guys. I mean, that's what the problem is. When do you want to try this? Let's get this done, because you guys aren't listening to what I'm trying to tell you. Counsel, were you intending on giving them an offer of judgment? Your fees are going to be paid if this goes through and get a verdict in excess. I mean, I don't know what your intentions are.
My client and I will discuss that.
Because I just want to give enough time for that to, late July. July 26th. Non-jury trial in this matter. Discovery being closed will be set July 26, 2023, 9 a.m. in person.
What time was that?
Set at 9 a.m. in person. You got to have all your witnesses, documents, evidence here. And we'll go for counsel. That'll give you a time to do an offer of judgment so that if it does come down to that, your fees will be paid. Yes.
Your Honor, that doesn't give us enough time to seek counsel and to do the things that we're gonna need to do here.
You started this case in February. It is now the end of May. That's 60 days out for trial. Discovery's closed. I don't know why it can't be tried now. You're intending on getting an attorney?
Absolutely.
Well, and I'd suggest that you do that as soon as possible. If they need more time, then certainly the court would entertain a motion to adjourn the trial date. But otherwise, as the posture of this case sits right now,
Okay.
Don't interrupt me. We're gonna have a way to, you know what? Tell you something, Mr. Montgomery.
Excuse me, I can't.
No, you'll hear me. I'm gonna tell you right now, I expect people to conduct themselves in certain ways in my courtroom. I don't know, just listen to me. I don't want this other stuff in terms of comments that I'm making. I will show you respect, but the one thing I will not let happen, ever. You can sit up there and you can disrespect me all you want, but I will never let this institution in this courtroom be disrespected. So I'd suggest that you watch after I say something, what comes out of your mouth.
This is the eruption point, and it's classic Judge Simpson. Courtroom authority is sacred and disrespect cuts deep. Watch how he flips the script. He doesn't just protect himself, he defends the institution of the court. That's powerful. Why? Because it reminds everyone that the courtroom is bigger than one judge, one case, or one mechanic. It's about upholding justice. Notice the escalating warning. He's already let small comments slide, but when they cross the line again, he snaps back with thunder. You're going to feel the full wrath of this robe. That's not metaphor, that's a threat of contempt, powers, fines, or even jail time if behavior continues. This moment underscores why courtroom conduct is everything. So let me throw this at you. Do you think judges should crack down this hard on disrespect, or does passion sometimes excuse a sharp tongue in court?
Because whether or not you're intending to give that impression, you certainly are to this court giving that impression. And if you continue to do that, and you've done it 2 or 3 times today, and I let it slide, but if you continue to do that, you're going to feel the full wrath of this robe come down on you, and I don't want to do that. Am I understood?
Yes, Your Honor.
Thank you. We'll see you in July.
And with that, Judge Simpson slams the gavel figuratively, if not literally, setting a trial date and making it crystal clear who holds control in this courtroom. What's the takeaway here? Cases like this hinge not just on the facts, but on the evidence, the timing, and the credibility of both sides. The plaintiff's challenge is monumental, proving a repair wasn't done years after the fact, with gaps in proof and no solid documentation. Meanwhile, the defense leans on receipts and time, 2 of the strongest shields in civil litigation. Judge Simpson showcased why courts aren't theaters of emotion, but arenas of logic, evidence, and order, and his authority, unshakable. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.